Hello everyone. Very good evening to all of you. Welcome to the Officer Adda channel of Adda 24/7. So today we are going to start the SURFACE Act. This is one of the most important act. Okay. So let's start with the SURFACE Act. So what actually the SURFACE Act is? Suppose if a borrower have taken the loan from the bank and the financial institution. So without intervention of the court, how the bank and financial institution can take the money from the borrower? This is your SURFACE Act. Okay. So in this particular topic we have to study I think 7 to 8 chapter, because 7 to 8 chapters are given in your BRBL book. So that's why this chapter is very much important, and at least 8 to 10 questions come from the SURFACE Act. Okay, now let's start with the session. Okay, just give me a minute. Yeah, so this act was enacted. Okay, what is this? This act was enacted with the aim to provide a structured platform to the banking sector for managing its amounting NPA stocks and allow bank and financial institution to take possession of securities and sell them. The act has been largely perceived as of facilitating assets recovery and reconstruction. Prior to this act, the legal framework relating to the commercial transaction lagged behind the rapidly changing commercial practices and the financial sector reform, which led to slow the recovery of defaulted loans and mounting level of NP of the bank. The comfort available for the lender for his money to come back will give him a confidence for lending. So this is basically about your NP. Suppose if amount is declared as an NPA, that is non-performing asset, then the bank and financial institution can do this thing. Okay. Now the question is, first is bank obtains security while lending so that the case of need the money can be dash of security. The money can be dash of security. So what is this? Money can be, that is released by sale. Released by sale of security. Okay. Now the SURFACE Act is applicable to the housing finance company whose name is notified by the central government. That is true and false. So this is absolutely true one. Okay, this is applied. Whether movable security in possession of the bank can be sold by bank without intervention of the court. Is that right or wrong? So without intervention of the court, yes, because SURFACE has made the provision to that effect. Okay, next. As per the law existing today, the mortgage security cannot be sold without a court intervention. This is correct. Yes, the court intervention is required as per provision of TP Act. No, SURFACE Act has now enabling provision. Yes, since the contract has made no provision about any court intervention. No, due to the recent amendment in the transfer of property, no court intervention is required. So for that one, B is the right answer. No, SURFACE Act has now made the enabling provision. So B is the right answer for this question. Next, provision of SURFACE Act apply to which security? First, any movable or immovable security charged to the bank or financial institution. To mortgage security only. C, where the security interests are created for repayment of financial assistance given by bank or financial institution to the property owned by defaulter borrower, but those that are not charged to the bank. So SURFACE will apply to which security? Security interest which is created by repayment of financial assistance given by bank and financial institution. So this is the right answer. Is that okay? So this is the right answer for this question. Now let's start with the next question. Maria Chemical is one of the famous case of SURFACE Act. So Maria Chemical case, the Supreme Court declare which particular provision as invalid? Entire SURFACE Act. Second, creation of security interest. C, formation of reconstruction company. D, condition to pay 75% of the amount as precondition while preferring appeal to the DRP. So which of the following is the right answer? So in the Maria case, basically, borrower have to pay 75% if he is going to DRT. This is absolutely arbitrary, unreasonable. So for the sixth one, D is the right answer for this question. Is that okay? D is the right answer. Next. So this is the second unit. In this unit, we have been seeing the various definition given in surfacing. The rationale behind enacting the act was to regulate securitization and reconstruction of financial assets and the enforcement of security interests created in respect of the financial asset to enable the realization of such assets. So basically what the SARFAESI Act is, without intervention of the court, how the bank and financial institution can take the money. So the SARFAESI Act provides for the manner for enforcement of security interest by the secure creditor without intervention of the court and tribunal. Is that okay? As per SARFAESI Act, any person aggrieved by the order passed by DRT can file an appeal to the authority, and that is called appellant tribunal, subject to the maintainability of the appeal. These tribunals are constituted by central government for the various state as per provision for the recovery of debt. So under this particular act, we have just read about the DRT and DRAT. So under SARFAESI, provisions can be also handled by the DRT and DRAT. Okay. The act providing the setup of ARC, that is an asset reconstruction company, which require NPA from the bank and financial institution by raising fund from the qualified buyer. So we know that if borrower is not able to pay the money, okay, then the bank will give security receipt to the ARC company. ARC company then will search the qualified buyer, and qualified buyer will take the security receipt and give money to the ARC company. Okay. It enable ARC to take possession of secured asset of the borrower, including right to transfer and release the secured asset. ARC buy the impaired asset from the bank and financial institution, cleaning the balance sheet of the bank and permitting them to focus on their normal banking business. In plain word, it is takeover of loan and advance from the bank and financial institution for the purpose of recovery. Done? Now, SARFAESI Act is applicable to the pledge security also. Pledge. It's applied to the pledge security also. The answer is absolutely false. For enforcement of mortgage security, court intervention is required even for action under SARFAESI Act. Court intervention is required. This is absolutely false. Bank and financial institution can issue notice for enforcement over security under SARFAESI only if these security are not in possession of creditor, only when the account is classified as, right now we have just discussed, when the account is classified as a NPA, then this process will be start. So for third one, NPA is the right answer. Next one, if the borrower does not pay within dash days after notice by secured creditor, the creditor can dash of the security. Tell me. So class, you have to learn 60 days, okay? And the creditor can, what? Creditor can, in this point, creditor can take possession, okay? Creditor can take possession of the security. Okay. Next. After receipt of notice from secured creditor for the payment of dues by borrower, the borrower is legally prevented from transferring his property. This is absolutely true, yes. The borrower cannot transfer the property. On request of secured creditor, the district magistrate and the chief judicial magistrate can take possession of security for handing it over to the creditor. That is absolutely true. Okay, because yes, we can take the help of district magistrate and the chief judicial magistrate. Seventh, when the management of the company is taken over by secured creditor, the director of such company are entitled to the compensation for the loss of office. Seventh one. That is absolutely false. Okay. The management of the company is taken over by secured creditor. The director is not it, because we know that the company have a different legal existence and the member have a different legal existence. That's it. When any bank or financial institution obtain a charge against property, okay, So when any bank or financial institution obtain a charge against property, with which authority will the transaction have to register under surface? Central Registry, ROC, Registrar of Insurance, what? किससे from which authority they have to register? So for 8th one, the right answer is Central Registry. When can the provision of SURFACE be invoked for proceeding against the charged property? When the bank feel that it is necessary for recovery at any time, when the RBI direct to do so, when there is a default in repayment by a borrower, or when there is default in repayment and the bank declare the account as empty. So what is the right answer? 91. We know that this one is the right answer. Okay, next. Whether existing or future receivable are property. This is yes, no, yes, but if and when a charge to the lender, and no if hypothecated to the lender. So what is hypothecation? The implied pledge is called hypothecation. So for 10th one, the right answer is yes. From the following, which function is of securitization company? Acquisition of loan transaction from the lender, help the lender in recovery of sale by of charged property, take legal step against defaulter borrower on the behalf of lender, acquisition of financial assets from the originator. So which of the following is the right answer? 11th one. Acquisition of financial asset from the originator. So class, this is just a quick revision in which we are just covering everything of the SURFACE Act. Okay, next. Now this is about the ARC company. Okay, this is about your ARC company, that is Asset Reconstruction Company. It include the registration of these company, their functional freedom and RBI restriction thereon. There are some stipulation for capital requirement and for raising the same. The existing company require registration. There are various conditions based on which registration is considered by RBI. We have seen when registration of the company can be cancelled and reason thereof. How financial assets are acquired is important, and it involves detailed procedure. The effect of contract deed suit involving the security asset is also seen. See, so this is all about your asset reconstruction company. So suppose if any company want to open the ARC company, so the registration or the permission with the RBI is required. The ARC company can take various measures for realization of from the assets. The Act provides for dispute settlement between bank, financial institution, asset reconstruction company, and the qualified buyer by the arbitration. RBI has power to issue various guidelines under the Act. So this is the right answer. Okay, now ARC company needs registration from the RBI for the commencement of the business. That is true and false. So this is absolutely true. Okay. Right of acquisition of financial assets by the ARC is subject to the prior agreement or contract about the asset. That is true. That is totally false. Acquisition of financial asset by ARC is with liability also over such an asset. For each asset acquired or to be acquired by the ARC, there should be dash scheme. There should be a separate scheme. When ARC company issues security receipt, the holder is entitled to dash of the financial asset. That is undivided interest. Undivided interest. The security receipt issued by ARC required registration. It also requires registration? The answer is no. Any direction issued by RBI under the SURFACE Act has dash effect and is dash on the party. 7th one. That is a statutory effect and binding on the parties. Okay. After application of SURFACE Act, what have the existing company to do about registration with RBI? 8-1. The right answer is they have to get registered within 6 months from the commencement of this act. Which from amongst the following is a reason for cancellation of registration of ARC company without giving a hearing opportunity? Tell me. The company does not keep account as per RBI norms. The company ceases to carry on the business. The company failed to hold investment from the qualified investor, and the company does not fulfill any of the condition imposed by registration. 91. That is B is the right answer. Is that okay? Now, in this chapter, we have seen details about the enforcement of security by bank and financial institution and the procedure requirement. We have discussed how on default being committed by borrower, the creditor can enforce the security as per the SARFAESI Act. No court intervention is required. Yes. The service of notice calling for payment and falling to the pay, creditor can invoke the provision for the takeover the asset and management. After the notice, transfer of property by the borrower is prohibited because we have just informed the borrower, so he cannot do anything with the property. The borrower may, on receipt of the notice from the secured creditor, may make representation and raise objection, in which the case secured creditor has to consider the representation and objection. That is important. Creditor can also call for payment due to the borrower from the third party, and for the remaining dues after the sale of asset, the remedy of civil court or DRT is open as per jurisdiction. For initiating various action under the Act, there is a need for unauthorized person. While taking possession of asset, various precautions are required to be taken. For taking possession, the help of Chief Metropolitan Magistrate and District Magistrate or any authorized officer can be taken. That is important. In such an event, the possession is taken by such authority and handed over to the creditor. Against the possession notice, appeal can be made, but on payment of the amount as prescribed. If possession is wrongfully taken, the creditor has to pay compensation to the borrower. For appeal to the tribunal, 50% amount we have to pay, then only we can appeal to the tribunal. Now, ARC means what? Yes, class. ARC means what? By ARC, asset reconstruction means dash by the ARC company or by any right or interest of the creditor in respect of any. ARC is the acquisition, okay, by the ARC company of any right or interest of the creditor in respect of the any financial assets. Financial assets, okay. Surfaces applicable to Arabic. This is absolutely yes, 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 yes. Mortgage or asset-backed debt instrument can be issued by ARC to the general public. No, it is not to the general public. No. Guarantor to the loan is with the meaning of borrower, yes, because if the borrower is not able to pay the money, we can just knock to the guarantor also in this case. Surface is applicable only when there is a security. That is absolutely true. Has surface defined hypothecation? Yes, yes. Section 2 clause N. Section 2 clause N define this one. Sixth, absolutely yes. On giving of a default notice by creditor, the borrower give a reply to it. What should the creditor do? Ignore the notice, wait until borrower initiate any legal action, give due consideration to repay, or take matter before DRT for solving. So what is the right answer? Give due consideration to reply as per requirement of section 13 clause 3. Okay, now on the sale of security asset, the sale proceed are appropriated firstly 8-1 toward the satisfaction of dues of secured creditor, toward payment of dues of labor, toward the payment of costs, charges, expenses. Now, central registry. Central Registry of SARFAESI, that is CERSAI. So first of all, you have to learn the full form also. So full form of CERSAI is Central Registry of Securitization, Asset Reconstruction and Security Interest. Was set up by central government. CERSAI shall be maintaining and operating the central registry for and behalf of central government. At present, the particular of transaction required to be filed with CERSAI by bank and financial institution The charges will be effective from the date of registration of charge by CAIIB. Registration under or other applicable law will continue. All transaction and creation of security interest need to be noted. Modification and satisfaction also need noting in prescribed form with payment of fees and within stipulated time. Okay, question is, after coming into operation, the provision relating to central registry, the bank and financial institution will have to register all the security interest. That is true and false. That is true. The period stipulated in the Act for recording satisfaction of security interest is a dash day from the date of such payment, within 30 days. Duty to report satisfaction of charge to the central registrar is on creditor or on the borrower. That is on the creditor, that is bank and financial institution. Beside the SURFACI Act, some other laws require some registration of charge creating the property. So is that double registration is avoidable? Fourth one. Yes, the creditor can choose under which the law he need registration. No, registration under SURFACI Act as well as any other applicable law will have to be made, as the SURFACI Act is not the substitution of any other law. Yes, if one charge noting is by registered document. No, as the civil court and DRT have a jurisdiction against properties, both registration is required. So for the fourth one, the right answer is B. No, the registration under SURFACI as well as other applicable law will have to be made under SURFACI is not the substitution of it. Okay, so we don't need the double registration. Is that okay? Next. Contravention. Attempt to contravene or its abatement is an offense under the Act, which is punishable as per the provision. Yes, we know that if we not follow the rules and regulations of SURFACI, the provision is there. However, cognizance is required taken only on receipt of complaint from the appropriate authority. Only a metropolitan magistrate or judicial magistrate of first class has power to take cognizance. This is very important. Metropolitan magistrate and judicial magistrate of first class have a power. The statute determined the adjudicating authority who may impose penalty for the various contravention while allowing appeal by the party aggrieved or by the decision of adjudicating authority. The appellant authority usually designate as such by Central Board of RBI by an order stay the enforcement of the order passed by adjudicating authority. So adjudicating authority is the particular authority for giving the justice. The appellant authority is appointed by whom? Tell me. RBI, Finance Ministry, Supreme Court, or none of the above? Appellant authority. So this is always appointed by the RBI. So first A is the right answer. Can honorary magistrate take cognizance? So we have learned the honorary magistrate. The answer is no. It's only a district magistrate or judicial magistrate of first class. So this is absolutely okay. Next. SURFACI Act is applicable to security not in possession to the secured creditor. Yes, we have seen the law list of security in which Act is not applicable. Exactly. Act has to be dealt with the situation for offences committed by individual, partnership and company. So individual, partnership, company can be the borrower. By debarring the civil court or any other authority for jurisdiction for giving injunction, the implementation of the Act is made effective by removing the legal hindrance which otherwise the borrower can bring. We have also seen how and when Act has an overriding effect. The Act has provided that the provision of Limitation Act is applicable for the action taken under this Act. The central government has power to make rules for procedural implementation of the Act, including directing that any of the provision of this Act shall not apply to such class or classes of bank or financial institution and apply to the class and classes of bank and financial institution. So it is totally in the hand of central government that which provision will be applied to the which bank and which financial institution. The central registry has been set up and the provision relating to the registration required under this section 21 to 27 is applicable. The chapter also has dealt with the power of central government to remove the difficulty that may be arising under this Act. Okay, now for challenging action initiated by secured creditor against the defaulting borrower under SURFACI, the borrower can go to the civil court for injunction. And what is injunction? Injunction is basically the power of the court to give the order. So for this one, the right answer is absolutely false. Can bank take action under SARFAESI against the deposit under lien? So lien is apply. The answer. Hire purchase, apply. After bank notice a defaulting borrower has paid within 60 days a substantial amount and the present dues are 15 lakh, which is 15% of the claim amount, can bank proceed to take possession of security? Fourth, that is. Okay. If some point the provision of TP Act and SARFAESI Act is different, so which act will prevail? One and only SARFAESI Act will prevail. Can a bank proceed to take possession of security after the 4 year of causation? So this is a little bit fast, but it's still that is very important for the examination point. Okay. Provision of SARFAESI is applicable to which of the following? Pledged goods, mortgage property, security that is not otherwise charged to the secured creditor, security charged to creditor and not in possession of the creditor. So which of the following is the right answer? This is the right answer. When do the rules framed by central government under the Act get validity? After the appellate tribunal of DRT approved them, on Supreme Court approving the same, immediately on framing the rules by government and notifying the same, when the both House of Parliament approved the rules. So which of the following is the right answer? So whenever the central government make the rule, it have to be present before the both House of Parliament, then only the law can be. So this is the right answer. Now the last particular chapter. In this unit, we have to deal with the amendment that is done in SARFAESI Act in 2013 in 2016. Okay. This amendment, while are included as addition to section 26, deal with the various issues such as rectification of error during the registration, priority of the secured creditor, registration of security interest, okay, where there's a no secured creditor, condition for exercise the enforcement right by the secured. So this is the things, this is amended into. The central government may extend the time for registration of transaction of security interest or securitization or asset reconstruction or modification for a maximum period of 30 days only. Tell me, class. So, what is the right answer? First, so this is absolutely false. Okay. The Income Tax Department considered attaching the property in Jammu Kashmir belonging to Mr. X for recovery of tax due. It's such attachment order required to be filed with Central Registry. That is absolutely yes. Okay. When security interest upon any property in favor of secured creditor are filled for the purpose of registration, the claim of such secured creditor holding attachment order shall have priority over any such subsequent security interest created upon such property. Third is absolutely true. Recovery of tax by government department will have priority even after registration of security interest by secured creditor. That is false. Okay, so this is the right answer for this question. So I hope so. This is all for today's class. Okay, so if you want to take this revolution batch, the batch is already started. You have to apply the coupon code Y3.